representative as parties, where the action is allowed to be prosecuted or defended by a representative or someone acting in a fiduciary capacity. The beneficiary shall be included in the title of the case and shall be deemed to be the real party in interest. A representative may be a trustee of an express trust, a guardian, an executor or administrator, or a party authorized by law or the rules. An agent, acting in his own name and for the benefit of an undisclosed principal, may sue or be sued without joining the principal, except when the contract involves things belonging to the principal. Okay? A representative is not the party who will actually benefit or suffer from the judgment of the case. The rule requires that the beneficiary be identified as he or she is deemed the real party in interest. This means that acting in a representative capacity does not turn into a real party in interest someone who is otherwise an outsider to the cause of action. This rule enumerates who may act as representatives, including those acting in a fiduciary capacity. While not an exhaustive list, it does set a limit by allowing only those who are authorized by law or the rules. In environmental cases, this section may be used to bring a suit provided that two elements concur. First, the suit is brought on behalf of an identified party whose right has been violated resulting in some form of damage, and second, the representative is authorized by law or the rules of court to represent the victim. Let's discuss the case of Ang versus Spouses Ang, GR number 186993, August 22, 2012. The facts in this case are as follows. Respondents obtained a loan from petitioners. However, despite repeated demands, the respondents failed to pay the petitioners. Notwithstanding the receipt of a demand letter, the respondents still failed to settle their loan obligation. On August 6, 2006, the petitioners, who were then residing in Los Angeles, California, United States of America, executed their respective special powers of attorney in favor of attorney Eldridge Marvin Aceron for the purpose of filing an action in court against the respondents. Attorney Aceron, on behalf of the petitioners, filed a complaint for collection of sum of money with the Regional Trial Court of Quezon City against the respondents. Respondents moved for the dismissal of the complaint filed by the petitioners on the grounds of improper venue and prescription. Insisting that the venue of the petitioners' action was improperly laid, the respondents asserted that the complaint against them may only be filed in the court of the place where either they or the petitioners reside. They averred that they reside in Bacolod City while the petitioners reside in Los Angeles, California, USA. Thus, the respondents maintained the filing of the complaint against them in the RTC of Quezon City was improper. Respondents further claim that the petitioner's grant of special power of attorney in favor of attorney Aceron, notwithstanding, the said complaint may not be filed in the court of the place where attorney Aceron resides, that is, RTC of Quezon City. They explained that attorney Aceron, being merely a representative of the petitioners, is not the real party in interest in the case. Accordingly, his residence should not be considered in determining the proper venue of the complaint. So obviously, the issue in this case is whether attorney Aceron is a real party in interest. The Supreme Court held that attorney Aceron is not a real party in interest in the case. Thus, his residence is immaterial to the venue of the filing of the complaint. Contrary to the petitioner's claim, attorney Aceron, despite being the attorney in fact of the petitioners, is not a real party in interest in the case. Interest within the meaning of the rules of court means material interest or an interest in issue to be affected by the decree or judgment of the case, as distinguished from mere curiosity about the question involved. A real party in interest is the party who, by the substantive law, has the right sought to be enforced. Applying the foregoing rule, it is clear that Attorney Aceron is not a real party in interest in the case, as he does not stand to be benefited or injured by any judgment in the case. He was merely appointed by the petitioners as their attorney in fact for the limited purpose of filing and prosecuting the complaint against the respondents. Such appointment, however, does not mean that he is subrogated into the rights of petitioners and ought to be considered as a real party in interest. Being merely a representative of the petitioners, Attorney Aceron, in his personal capacity, does not have the right to file a complaint against the respondents. He may only do so as what he did in behalf of the petitioners, the real party in interest. To stress, the right sought to be enforced in the case belongs to the petitioners and not to Attorney Aceron. Clearly, an attorney in fact is not a real party in interest. The petitioners' reliance on Section 3, Rule 3 of the Rules of Court to support their conclusion that Attorney Aceron is likewise a party in interest is misplaced. Section 3, Rule 3 of the Rules of Court provides that the beneficiary shall be included in the title of the case and shall be deemed to be the real party in interest. Nowhere in the rule cited is it stated, or at the very least implied, that the representative is likewise deemed as the real party in interest. The said rule simply states that in actions which are allowed to be prosecuted or defended by a representative, the beneficiary shall be deemed the real party in interest and hence should be included in the title of the case. Okay, another case, Marcos Araneta versus Court of Appeals. GR number 154096, August 22, 2008. The facts in this case are as follows. Irene Marcos Araneta instituted before the RTC Branch 17 in Batac, Ilocos Norte, two similar complaints for conveyance of shares of stock, accounting and receivership against Benedicto Group with prayer for the issuance of a temporary restraining order. A motion to dismiss was filed on the ground of, among others, improper venue. During the preliminary proceedings on their motion to dismiss, Benedicto and Francisca, by way of bolstering their contentions on improper venue, presented the joint affidavit of Hilmia Valdez, Catalino Bactat, and Conchita Rasco, who all attested being employed as household staff at the Marcos Mansion in Barangay Lacob, Batac, Ilocos Norte, and that Irene did not maintain residence in said place, as she in fact only visited the mansion twice in 1999, that she did not vote in Batac in the 1998 national elections, and that she was staying at her husband's house in Makati City. Against the aforesaid unrebutted joint affidavit, Irene presented her 5 peso community tax certificate issued on November 7, 1999 in Curimao, Ilocos Norte to support her claim or claimed residency in Batac, Ilocos Norte. The RTC dismissed the complaints on the ground of improper venue. Pending resolution of her motion for reconsideration, Irene filed a motion to admit amended complaint, attaching therewith a copy of the amended complaint in which the names of Daniel Rubio, Orlando Reslin, and Jose Reslin appeared as additional plaintiffs. As stated in the amended complaint, the added plaintiffs, all from Ilocos Norte, were Irene's new trustees. Parenthetically, the amended complaint stated practically the same cause of action, but as couch sought the reconveyance of the shares only. Okay, so the RTC issued an order entertaining the amended complaint. So the issue in this case is whether the defect in the venue was cured by the additional plaintiffs. Petitioners, in an attempt to establish that the RTC in Batac, Ilocos Norte is the proper court venue, asseverate that Batac, Ilocos Norte is where the principal parties reside. Pivotal to the resolution of the venue issue is a determination of the status of Irene's co-plaintiffs in the context of Section 2 and 3 of Rule 3 in relation to Section 2 of Rule 4, which provides for the parties in interest and representative as parties. There can be no serious dispute that the real party in interest, plaintiff, is Irene. As self-styled beneficiary of the disputed trust, she stands to be benefited or entitled to the avails of the present suit. It is undisputed, too, that petitioners Daniel Rubio, Orlando Reslin, and Jose Reslin, although all from Ilocos Norte, were included as co-plaintiffs in the amended complaint as Irene's new designated trustees. As trustees, they can only serve as mere representatives of Irene. Section 2, Rule 4 indicates quite clearly that when there is more than one plaintiff in a personal action case, the residences of the principal parties should be the basis for determining proper venue. According to the late Justice Jose Feria, the word principal has been added in the Uniform Procedure Rule in order to prevent the plaintiff from choosing the residence of a minor plaintiff or defendant as the venue. Eliminate the qualifying term principal, and the purpose of the rule would, to borrow from Justice Regalado, be defeated where a nominal or formal party is impleaded in the action, since the latter would not have the degree of interest in the subject of the action which would warrant and entail the desirably active participation expected of litigants in a case. The case of Guizano v. Veneracion, GR number 191128, September 12, 2012. The facts in this case are as follows. Reynaldo filed a complaint against Carmencita and the Santos spouses, praying that Carmencita, as owner or as the lawful attorney in fact of her son Manuel, be ordered to reconvey the 656 square meter parcel of land in his favor or in Reynaldo's favor. The complaint was docketed as a civil case and raffled to Branch 81 of the RTC of Malolos, Bulacan. In her answer, Carmencita claimed that the complaint was without merit since the property subject of the sale between Reynaldo and the Santos spouses is part of the property owned and registered in the name of her son Emmanuel. Reynaldo thus had no cause of action against her. Carmencita's heirs argue that the action should be dismissed as it was directed against Carmencita, who was not the real party in interest, as she was not the registered owner of the property from where the lot was taken. Emmanuel, the registered owner, was not even impleaded in the case. The issue in this case is whether the action was properly filed against Carmencita. The Supreme Court held that the complaint was not filed against the real party in interest. Reynaldo filed the present complaint to compel Carmencita to execute a deed of acknowledgment or reconveyance over the subject property in his favor. Notably, he filed the present action only against Carmencita, despite his knowledge that the subject property is registered in Emmanuel's name. In the prayer portion of his complaint, Reynaldo further asserted that he filed the present action against Carmencita as either the owner of the subject property or the lawful attorney in fact of Emmanuel. As Reynaldo himself recognized in his complaint, the subject property is registered under Emmanuel's name alone. Carmencita's name does not appear anywhere on the title. While Reynaldo alleged that Carmencita was the owner of the property subject of dispute, with Emmanuel acting as a mere nominal owner, a torrent certificate is the best evidence of ownership over registered land and serves as evidence of an indefeasible title to the property in favor of the person whose name appears on the title. Okay? Absent any evidence to the contrary, Emmanuel is a real party in interest in any action that seeks to challenge ownership of the registered property. Reynaldo should thus have filed his complaint for reconveyance against Emmanuel. While the lower courts considered Carmencita to be Emmanuel's attorney in fact, the Supreme Court found no evidence on record that Emmanuel ever authorized his mother to represent him in this action. Even assuming that Carmencita did act as Emmanuel's attorney in fact, it is well established in our jurisdiction that an attorney in fact is not the real party in interest. Even if so authorized in the power of attorney, she cannot bring an action in her own name for an undisclosed principal. Since Reynaldo was obviously aware of the fact that the subject property was registered in Emmanuel's name, he should still have included Emmanuel as a defendant in the reconveyance case pursuant to Rule 3, Section 3 of the Rules of Court, providing that where the action is allowed to be prosecuted or defended by a representative or someone acting in a fiduciary capacity, the beneficiary shall be included in the title of the case and shall be deemed to be the real party in interest. The next case, V. Gent Incorporated versus Morningstar Travel and Tours Incorporated, GR number 186305, July 22, 2015. The facts in this case are as follows. Petitioner V. Gent bought 26 two-way plane tickets from the respondent Morningstar Travel and Tours Incorporated. V. Gent returned a total of 15 unused tickets worth $8,747.50 to the defendant. Of the 15, Morningstar refunded only 6 tickets. Morningstar refused to refund the remaining 9 unused tickets despite repeated demands. Petitioner V. Gent filed a money claim against Morningstar for payment of the unrefunded $5,301.88 plus attorney's fees. The complaint was referred to Branch 2 of the Metropolitan Trial Court of Manila and docketed as a civil case. Now, Morningstar questioned V. Gent's personality to file the suit. It asserted that the passengers in whose names the tickets were issued are the real parties in interest. After due proceedings, the METC dismissed the complaint for lack of cause of action. Citing Rule 3, Section 3 of the Rules of Court, it declared that as agent of the passengers who paid for the tickets, V. Gent stood as the real party in interest. So the issue in this case is whether V. Gent is a real party in interest. V. Gent argues that it is a real party in interest with legal standing to institute the complaint against Morningstar. V. Gent admits that it purchased the plane tickets on behalf of the passengers as the latter's agent. The tickets were issued in the name of the passengers and paid for with the passengers' money. No dispute or conclusion in the lower court's minds on this point. Hence, both the MTC and the CA commonly found that V. Gent acted as an agent of the passengers when it purchased the passengers' plane tickets. The Supreme Court held that every action must be prosecuted or defended in the name of the real party in interest, the party who stands to be benefited or injured by the judgment in the suit. In suits where an agent represents a party, the principal is the real party in interest. An agent cannot file a suit in his own name on behalf of the principal. Well, the same rule, Rule 3, Section 3 of the Rules of Court, also provides for the exception when an agent may sue or be sued without joining the principal. The rule provides that an agent acting in his own name and for the benefit of an undisclosed principal may sue or be sued without joining the principal, except when the contract involves things belonging to the principal. Thus, an agent may sue or be sued solely in its own name and without joining the principal when the following elements concur. Number 1, the agent acted in his own name during the transaction. Number 2, the agent acted for the benefit of an undisclosed principal. And number 3, the transaction did not involve the property of the principal. When these elements are present, the agent becomes bound as if the transaction were its own. This rule is consistent with Article 1883 of the Civil Code, which provides that if an agent acts in his own name, the principal has no right of action against the persons with whom the agent has contracted, neither have such persons against the principal. In such case, the agent is the one directly bound in favor of the person with whom he has contracted, as if the transaction were his own, except when the contract involves things belonging to the principal. The provisions of this article shall be understood to be without prejudice to the actions between the principal and agent. So in the present case, only the first element is present. The purchase order and the receipt were in the name of Vigent. However, the remaining elements are absent because Vigent disclosed the names of the passengers to Morningstar. In fact, the tickets were in their names, and the transaction was paid using the passengers' money. Therefore, Rule 3, Section 3 of the Rules of Court cannot apply. To define the actual factual situation, Vigent, the agent, is suing to recover the money of its principals, the passengers, who are the real parties in interest because they stand to be injured or benefited in case Morningstar refuses or agrees to grant the refund because the money belongs to them. From this perspective, Vigent evidently does not have a legal standing to file the complaint.